Good morning, my lord.
Yes, let us start the proceedings. Yes, call the list.
Good morning, my lord.
Good morning.
From daily causes, under the heading to be mentioned, second appeal 125 of 16.
इसमें वो जो 4 दिन का समय हुआ था
125 of 16.
Okay. There's a typographical error in the order dated 3/2/2022. Full stop. The year of the second appeal has been wrongly typed. Full stop. The error be corrected and the case number be read as second appeal 125 of 2016.
Under the heading orders with defect, serial number 2, MN number 9 of 22, Mr. Rahul Kumar Gupta, Mr. Akshay Verma.
Okay. Second appeal.
MN.
This
गलती से लग गया ना उसको हटा दो
yes, where is Mr. Gupta? Where is Mr. Gupta? Yes. Achinta-san, what is this matter about?
Yes, Lordship, Your Lordship, with last order, Your Lordship had directed us to file the certified copy of the order impugned, which we have filed it yesterday, Your Lordship. Through mail, Your Lordship may take it up after a week, Your Lordship. Next week or week, yeah.
The defects are removed?
We have filed it. Your Lordship had directed us to file the
I have not
certified.
directed anything.
Your Lordship may kindly see the last order.
Why should I direct you to file an impugned order?
Impugned order is not on record. Council.
Mr. Counsel, why should
Yes,
I
yes.
will direct you to file an
No,
impugned
no,
order?
no. I
Because the
it is
mandate
my fault.
mandate in the procedure. Why are you
Yes,
saying
yes.
that as per your direction? So tell me the defect is removed or not?
Yes. All the defects. Otherwise, but Your Lordship, therefore I was praying that Your Lordship may take it up.
When did you file the supplementary affidavit?
Yesterday online we have filed. Therefore, today we will be filing the hard copy of the document.
List this case next week under the appropriate heading.
Under the heading for orders, serial number 3, MN number 234 of 16, Ms. Mahua Pali.
I am for the appellant, my lord.
Yes.
In this, I am for the limitation petition, only 45 days delay in filing the appeal, my lord. I have stated at paragraph 5 of this limitation petition, 5 and 6, my lord. I have stated, my lord. Against the judgment dated 19/1/2016, I have applied for certified copy on 28 for January 2016, my lord. And this appeal has been filed in the month of May 2016, my lord. Only 45 days delay, this appeal may be allowed, my lord.
Employees compensation application. Who is appearing for United India Insurance Company Limited?
Lordship, I am appearing, Lordship, in this case. Respondent number 2, Lordship.
You are appearing on respondent number 2.
Yes, Lord.
You are the workman.
I am the Khalasi of that of the draft, my lord. And opposite party number 1 is the driver.
Okay. Yes, you are the Khalasi.
Yes, my lord. On the point of jurisdiction, my lord, this appeal has been dismissed in the court below, before the tribunal.
Only on the point of jurisdiction it has been dismissed.
Yes, my lord. Only point.
You are a permanent resident of
Dhanbad, my lord. I am residing in Dhanbad, my lord. Exhibit X series, my lord, all the documents have been submitted, my lord, before the tribunal.
take down IA number 1. So you have no objection, yes, Mr. Dhamir Kumar?
Yes, lords.
There is 45 days delay in filing this appeal. Next file. The learned counsel for the appellant submit that the appellant became handicapped due to the accidents. Thus, it took some time to file this appeal. Also, considering the submission, I find that sufficient ground has been shown to condone the delay. Delay condoned. IA allowed. Full stop. Place this case under hearing for admission.
Apply.
Serial number 4, MA number 314 of 16. Mr. Vishnu Kumar.
Yes, who appears? Who is respondent number 2 and 4? Who is appearing for 1? Respondent number 1, the claimant. Who is appearing? No one appears on behalf of the appellant. Full stop. None appears on behalf of the respondent also. Full stop. List this case on a date when the court hears the cases physically.
Serial number 5, MA number 390 of 16. Mr. Arun Kumar, Bardha Appellant.
I am appearing for respondent number 1 in this case, my lord.
Yes.
Yes, my lord, for the condemnation of delay, my lord, the 107 days, my lord. By the appeal of the complainant, my lord, he filed a complaint for, filed the appeal, my lord, for the interest part, my lord, from the date of filing, my lord, though, my lord, was the interest.
There is right of recovery, my lords, and owner is also appearing. Mr. Vikas Kishore Prasad name is appearing.
Owner of the insurance company is appearing.
I am appearing for the insurance company, my lords.
Who is for the owner?
Name of Mr. Vikas Kishore Prasad is there, my lords, in the
What
list.
is it? Where is Mr. Vikash Kishore Prasad?
Because there is right of recovery in this case, my lord.
No, there is no wakalatnama of Vikash Kishore Prasad.
Name is appearing, my lord. You have to see the list.
No. Just check the wakalatnamas. Owner is respondent number 2.
Yes, 2, my lords. 3 and 4 are per forma respondents. 2 is owner, 1 is insurance company.
Owner is from which place?
Address has been given, my lords, of Delhi. Haridhar Kaur, wife of Jasveer Kaur.
It has not been served. Take down. The notice upon respondent number 2 has not been served. Fresh notice through ordinary process at the correct address. Requisites 3 weeks.
Serial number 6, MA number 403 of 16, Mr. Vijay Kumar Rao, for the appellant.
Nice.
My lord.
Yes.
So I am on behalf of the claimant and your lordship for enhancement of the award. Notice.
You have not filed notices, requisites.
My lord.
You have not
2
filed
weeks
requisites.
2 weeks further my lord फाइल कर देंगे हमको उस बीच में
Earlier
आप
orders, the earlier orders in relation to filing of requisites and service of notice has not been complied by the learned counsel. Well, by the applicant, full stop. By way of last indulgence, 2 weeks time is granted to comply all the orders.
Serial number 7, MA number 410 of 16, Mr. DC Jha, for the appellant.
Yes, who appears? Where is Mr. GC Jha? There's some problem with your audio. You log out and then again then log in. Who is respondent number 5? Who is respondent number 5? Kumar. Unmute yourself, Mr. Jha.
Am I audible?
Yes, Mr. Jha, fresh notice to respondent number 5.
Yes, notices has already been issued, Your Lordship, on 26/2/2020.
Issue fresh notice to respondent number 5 by ordinary process, requisites to be filed within 2 weeks.
Lordship, if any return copy, that may kindly be allowed to be
There's
used.
no written copy.
Okay, Lord.
Serial number 8, MA number 414 of 16, Mr. Ram Akshay Singh, Ms. Nanda Kumari, for the appellant.
Yes. Yes. Who is appearing, Mr. Aloklal?
In which item, Your Lordship? Item number 13.
Number 8.
8 is just, Your Lordship, I could not mark the list, my lord. I could not mark the list, Your Lordship.
Mr. Gupta, it was listed on 4-8. No, sorry. This is a 140 proceeding.
My lord, sorry, my lord, I could not mark the list. Neither am I aware of it, my lord. I'll find it out, my lord. And let it come after 3 weeks, Your Lordship. I'll find it out which insurance company it belongs. Because we could not mark the list, Your Lordship. ये देखिए तो किसका है ये वाला? चलो 414
The issue here is whether a pillion rider can be said to be a third party or not. Unmute yourself.
If it is an act liability policy only,
Yes.
then in that case not covered because of this thing, Tilak Singh and other judgments, Your Lordship. If it is an act liability policy, but I could not mark the list, Your Lordship. I will seek Your Lordship's indulgence for some time to ascertain which insurance company this is.
If it is an act only policy, tell me how do you define a third party?
Third party occupants are not the third party, my lord. There are certain judgments on this issue, Your Lordship, of the Honorable Supreme Court as well as our own High Court also, my lord, that the occupants are not part. The Surendranath Lumba 2009 Supreme Court, that would be the first case which has discussed with regard to the act policy and the package policy. Now, which is called as a comprehensive policy, it was then known. So, package policy and act policy, it is the Surendranath Lumba is the leading case in that case. Subsequent thereto, there are several judgments also. And prior to that, it was Tilak Singh. So, my lord, may I seek Your Lordship with utmost humility, my lord.
Mr. Aloklal prays for 1 week, 2 weeks time in this case.
My lord,
After 2 weeks.
May I ask the court master, Lord, today, which insurance company this case pertains to, Your Lordship?
You just ask later on, not during the proceeding.
Okay.
Serial number 9, MN number 439 of 16, Mr. GC Shah for the appellant.
Yes, Lordship.
Who is for respondent number 2?
Lordship, respondent 1 has filed Wakalatnama and order dated 22/20 may kindly be seen, Your Lordship.
Who is respondent number 2? What is his status?
He is the owner of the vehicle, Your Lordship. Owner of the commander chief.
Right to recovery has been given.
Perhaps not, Your Lordship.
What is the
No.
what is the appeal about?
Right to recovery has not been given, Your Lordship.
What
It
is
is a
that?
case.
What is this appeal for? What is the ground of appeal?
Yes, Lordship. First of all, Your Lordship, there is 100 days delay. IA petition is there, Your Lordship. And thereafter, the person injured was traveling on a commander jeep, UP number 84A6067, to attend a marriage. Issue number 4, Your Lordship, that is whether vehicle insured with OIC or not. Here is dispute, Your Lordship, that the commander jeep number such and such, which number is there, Your Lordship, for the same number, one Maruti Alto was insured with us, Your Lordship. And my branch manager appeared before this court and he exhibited that policy, Your Lordship, though the court has not believed on his statement and given the reasons, Your Lordship. That is on issue number 4, page number 8 and 9. That may kindly be seen.
Okay. Counsel for the respondent number 1 appears. No one appears on behalf of respondent number 2. Full stop. This IA has been filed to condone the delay of 100 days.
100 days.
Full stop. After hearing the counsel for the appellant and after going through this IA petition, especially paragraph 3 and 4, I find that sufficient ground has been shown to condone the delay. Stop. IA allowed, delay condoned. Place this case under the heading for admission.
May I interrupt for a moment, Your Lordship?
Yes.
In that case, the office may be directed to reflect my name.
Please don't interrupt. I don't like interruption during the proceedings.
Well, in that case, my name will already be.
Serial number 10, MA number 474 of 16, Mr. Mohammed Jayad Ahmad, Mr. Ramesh Kumar for the appellant.
Your Lordship, in the instant case, I am appearing on behalf of the appellant, Your Lordship.
Yes.
There is delay, Your Lordship, in the instant case in preferring this miscellaneous appeal, Your Lordship. This has been preferred for enhancement, Your Lordship.
Notice. Who appears for Oriental? Mr. Aloklal, you will appear on behalf of Oriental.
Yes, I'll accept notice, Your Lordship. Copy may be given to me.
Issue notice to respondent number 1. Ordinary process requisites 2 weeks. Full stop. The counsel for the appellant will serve 2 copies of this memo of appeal along with the IA and judgment to Mr. Alok Lal, who appears on behalf of Oriental Insurance Company Limited. Full stop. Let name of Mr. Alok Lal appear in the cause list as the counsel for the respondent number 2.
Serial number 11, MA number 503 of 16, Mr. Shyam Nasaria, Mr. Simple Dev, Mr. Akash Bhushan for the appellant.
Lordship, there is a delay of 321 days in preparing this appeal, and the grounds of the appeal is only for the interest rate. The interest rate is not given in this case. Only the interest rate should be given from the date of filing of the case.
Where is the mandate that it should be given from the date of filing?
Lordship, the matter is that the appellant is the claimant in the court below, Lordship, and he was the driving the vehicle, and due to the blast by the Naxalist, he died. He got injured and he died.
When was the claim? When was the claim petition filed?
Lordship,
when was the claim petition filed?
Limitation petition is IS 6559 of 2016. I have been filed.
2010, my lord's claim case was filed and decided on 25/7/2015.
5 years.
And there is right of recovery also, my lords. Name of 2 persons are appearing: Rajesh Kumar Matha and Ajit Kumar Sinha. Don't know for me.
Yes, who is appearing? Yes, Mr. Rajesh. Unmute yourself.
Yes, my lord.
You are appearing on behalf of the owner.
Respondent number 1, Your Lordship. Owner.
Okay. How many days? What are the grounds you have stated? This application has been filed to condone the delay of uh, 333 days in filing this appeal. Next para. Counsel for the appellants. I have heard the counsel for the appellant and the counsel for the respondents. First up, after going through the same, I find that it has been stated in this IA that due to the death of the sole bread earner, the appellants suffered great mental stress and agony. As a result, full stop. Further, it has been stated that the appellants being poor, appellants are poor, which poor person, full stop. It has been submitted that because of the aforesaid reasons, the appeal couldn't be filed on time, full stop. The respondent opposes, full stop. After going through the IA petition and the grounds mentioned therein, I find that sufficient ground has been shown to condone this delay. The delay is condoned as discussed under the report admission.
Serial number 12, MA number 519 of 16, Mr. DC Jha, for the appellant.
Yes, Lordship. This case there is delay of for 27 days, Your Lordship.
Who is appealing for the respondents?
Name of no name is not appearing for any advocate, Your Lordship, for respondent side.
Notice.
Lordship, notices has already been issued, Your Lordship, 1/10/2018, and I have filled the requisite, Your Lordship, on respondent 1 to 3. Notices issued on 18/9/18. 2 weeks time has been granted, Your Lordship. I have complied the order.
Notice upon respondent number 2 and 3 is validly served. Full stop. The service on respondent number 1 is invalid. Full stop. Fresh notice to respondent number 1, ordinary process. Requisites 2 weeks.
Serial number 13, MA number 534 of 16, Mr. Alok Lal, Mr. Santosh, for the appellant, Mr. Kalyan Banerjee, for the respondent.
Your Lordship, in this case, on the all last occasion, the notices were issued. One respondent has appeared. The status of other respondents are not known to me, Your Lordship.
The office has reported that the notice issued to respondent number 1 to 5 is validly served. Full stop. Respondent number 6 has appeared through Wakalatnama. Full stop. Next para. IA number 7. So how many days delay?
Delay of 45 days, Your Lordship.
There's a delay of 45 days in filing this appeal. Full stop. The reasons for the delay.
Para 5 onwards, Your Lordship.
Has been mentioned in paragraph 4, 5, 6, 7, 8, 9, 10. Full stop. Considering the statement made in the aforesaid paragraphs, I am inclined to allow this IA allowed. Delay condoned.
Serial number 14, MA number 538 of 16, Mr. Ashutosh Anand, for the appellant, no name appears for the respondent.
Made please, Your Worship. Your Worship, in this case, the insurance company is the appellant. The manner of appearance and the quantum is in dispute, my lords. If I am permitted to place page number 7, there's a delay of 61 days. What had transpired in this case? There was a road traffic accident.
Notice ordinary process requisites 3 weeks on both limitation and main application.
Serial number 15, MA number 542 of 16, Mr. Sachinandan Das, Mr. Praveen Kumar Chakraborty for the appellant, Mr. Amresh Kumar, Mr. Sekhar Prasad Sinha, Mr. Prashant
This
Kumar, Mr. Prithvish Kumar.
this is for enhancement of the mallet. And there is 43 days delay, mallet.
Yes, who is appearing for the respondent?
Respondent number Mahesh Mandal, respondent number 1, I am appearing. Owner of truck, no.
I am appearing for respondent number 2.
Have the counsel for the appellant, have the counsel for the respondent. This appeal is barred by limitation. First of the delays.
43.
Full stop. In paragraph 3, 4, 5, the delay has been explained. Considering the aforesaid statements in paragraph 3, 4, 5, I find that sufficient cause has been shown to delay of 43 to condone the delay of 43 days. Full stop, delay condoned. IA allowed.
Serial number 16, MA number 546 of 16.
One item, my lords, item number 13, my lords, I could not connected, my lord. Item number 13 for the respondent, my lord.
Wait, what happened to item number 30?
And IA allowed.
IA allowed under the ring for admission. Yes.
My lord, in this case, earlier notices were directed to be issued upon the respondents, my lord. This was occasion, my lord, but subsequently it has come in orders, my lord, so perhaps some notice might not have been served.
In this case, my lord, my submission is that the claimant has also filed one appeal, that is MA 593 of 16, my lord. Therefore, let both the
MA
593 of 16.
This case along with MA 593 of 2016.
My lord.
Serial number 17, MA number 557 of 16, Mr. Arvind Kumar Lal. For the appellant, Mr. Anjali Kumar, Mr. Pooja Kumari, Mr. Kumar Vishnu Narayan, and Mr. Amit Kumar Das for the respondent.
In this case, my lord, my humble submission is that the owner of the vehicle from whom the insurance company has got right to recovery, he has also filed one appeal, that is MA 594 of 16, my lord.
Just a minute. 594 of 16. This case along with MA 594 of 2016.
My lord.
Obliged to much.
Serial number 18, MA number 558 of 15, Mr. Manish Kumar, Mr. Amit Mishra, Mr. Rajesh Kumar Singh.
But in this case, there is limitation of 11 days.
Who is appearing?
I am appearing for respondent.
Mr. Chobe, you are appearing?
Yes, for respondent 1 and 2, both, my lord.
And Mr. Rajesh Mata. How many days delay?
11 days delay is there. 111 days, sorry, my lord.
121 days delay in filing this appeal. The reason. Grounds of the reasons for delay has been mentioned in paragraph 4 to 9. Considering the statement made in paragraph 4 to 9, I am inclined to allow this IA as the delay has sufficiently been explained. Condoned, delay allowed.
Serial number 19, MA number 581 of 16, Mr. GC Jha.
Yes, Lordship. This appeal has been filed.
6, Mr. Tejumashri for the respondent.
Lordship, it is a injury case, Your Lordship, disability matter, and several documents have been filed. I pray that let the lower court record be called in this case, Your Lordship, and notices upon respondent 1, 2 has already been issued. Name of 2 advocates is appearing from the respondent side.
Who is appearing?
Yes, I am appearing on behalf of respondent.
On behalf of whom? Who are the respondents?
Yes, sir.
Sankar Haldar, Your Lordship.
And for P. Hare Krishna Nair?
Sunil Kumar Pandit. Name of Sunil Kumar Pandit is appearing, Your Lordship.
Who is Sunil Kumar Pandit? As per report, it has not been served. Fresh notice on respondent number 2. Ordinary process requisites 3 weeks.
Lordship, may I pray in the meantime if LCR is called, Your Lordship, that will come.
Let it come under the name for admission. Let your delay be condoned first.
Serial number 20, MA number 590 of 16, Mr. Abhay Kumar Mishra, Mr. Bholanath Oja for the appellant. No name appears on behalf of the respondent.
Yes, Mr. Mishra.
My lord, may I please, your lordship, notices were issued on 12/7/2018. Requisites were also filed on 16/7/2018 itself. Lord, but since thereafter, in the list nobody appears, but what is the report? I do not know.
A notice issued upon respondent number 3 and 4 or valid 3 and 4 has been served validly. Full stop. Issue fresh notice to respondent number 1 and 2 ordinary process requisites 3 weeks.
Under the heading for admission, serial number 21, serial number 22, MA number 182 of 15 with MA number 331 of 16, Mr. D.C. Shah for appellant first case, Mr. Rajiv Kalyan, Mr. Asutosh Anand for appellant in second case, Mr. Rajiv Ranjan, Mr. Vijay Sinha for respondent in first case, Mr. D.C. Shah for respondent in second case.
Lordship, in this case, last occasion, just before the Lok Adalat, Your Lordship, this case has come.
Yes.
Yes, Lordship. And Your Lordship has indicated us for settlement of rupees 66 lakhs rupees, Your Lordship.
I have not indicated, the claimant said.
Yes, sir. That was his version, Your Lordship, claimant's version. Lordship, my submission is that because that amount was too high for our local office to settle, Your Lordship, the matter should have been sent to the head office, Your Lordship. And one thing only, Your Lordship, 20 lakhs and 50,000 we have already paid.
Yes.
20 lakhs we have paid in 2017, Your Lordship. So even 6% interest we have dekha jaya, Lordship, so that will about 5 to 6 lakhs rupees, Your Lordship, for 5 or 6 years. 2017 in January we have filed this amount, Your Lordship. So out of 66 lakhs, or if that amount is adjusted, I think this can be settled in Lok Adalat. Again, we will send this matter to our head office, Your Lordship.
No. Your submission, it is your submission. It is not the submission of the...
No, it's definitely, Lordship. My submission at that time, I was inadvertently, I could not point out this thing, Your Lordship.
What was the amount of compensation assessed by the courts?
Yes, Lord.
61,50,000.
Yes, Lordship. There is error, Your Lordship, one, because they have not deducted they have not deducted the amount, Your Lordship. For that, this amount has come to 61 lakh 50,000, Your Lordship. That is our main ground, Your Lordship. 1/4 should have been deducted. It was not deducted, so that takes about 15 lakhs rupees difference, Your Lordship.
Okay, and what is the appeal? What is the appeal by the claimant who is appearing?
That is for the enhancement, Your Lordship.
Yes, we will hear both. We will see Prashant Kumar Srivastav. Where is this appellant? Who is appearing on behalf of the appellants? Claimants. Abhishek is Sinha. Where are they? Connect them.
And Lordship, in this case, in conventional head also 1,75,000 has been granted, Lordship. That is also total compensation amount comes to.
On behalf of the claimants. Claimants. In these cases, first of the claimant is the appellant. Claimant is also the appellant in EMA number 331 of 2016. Full stop. List these cases when the court starts hearing the cases physically.
Lordship, may I submit?
Yes.
If this case is some may have had some difficulty with the claimant's advocate, Your Lordship, if this case is taken up next week, Your Lordship, so one more chance be given to him.
I don't know whether the claimant's advocate is in difficulty or whether they have not appeared for what reasons. Let the matters come of physical court, the physical court.
Serial number 23, MA number 231 of 15, Mr. Amresh Kumar for the appellant, Mr. Pradeep Kumar Nayak, Mr. Sushant Kumar Ganju, Mr. Arun Kumar for the respondent.
I am on behalf of the appellant, Your Lordship.
Yes.
This case is the insurance company has filed for the gracious passenger, Your Lordship. Disease was the gracious passenger. And it has, yes, Your Lordship, it has come in the deposition of the claimant also, Your Lordship. May kindly see the para 25, page 6 of the internal judgment. Honor, Your Lordship, PK Nayak is appearing, Your Lordship. In name is there, but last occasion is also not appeared, Your Lordship.
LCR is here?
Yes, Your Lordship.
LCR is here? Yes. Just check whether Mr. PK Nayak is there. Yes, Mr. Rich.
Yes, Your Lordship.
You have challenged this award only on the ground that the deceased was a gratuitous compensation.
Yes, Your Lordship. And also against the claimant, Your Lordship, that the future prospects given is 50% is the 40%, Your Lordship. That the disease was a liver, Your Lordship.
He was a laborer. How are you saying that he was a gratuitous passenger?
Yes, Your Lordship, that is it. May kindly see the page 6 of the internal page of the judgment, Your Lordship. Para 25.
Just a minute.
So respondent number 7 है, he cannot have fault for the matter.
Okay. LCR.
LCR already come. I think.
Yes, show me.
Yes, Your Lordship, page number 26, page number 6 of the internal judgment, Your Lordship, para 26.
PW.
AW1, Your Lordship, Clement's wife.
AW1.
1. Obviously, the Clement wife AW1 has in para 13 stated that the deceased husband at the relevant time was traveling as a passenger on the tractor. The FIR Exhibit 1, as contended by the insurer, also shows that the deceased is the relevant time was going to his uncle's house.
Read the exhibit. Read the FIR.
Yes, Your Lordship. मेरा नाम सुकरा उरांव है। Your Lordship got it?
Yes.
हाँ, उम्र 48 वर्ष और ये चित्रा उरांव इतना आज दिनांक 23/12 को समय लगभग 8 बजे सुबह सदर अस्पताल गुमला के पास आप गुमला थाना के पुलिस पदाधिकारी पे इतना बयान देता हूँ। मेरा लड़का लगभग 2 माह से श्यामलाल प्रसाद के यहाँ ईटा भट्टा मजदूरी का काम करता था और शाम में डोमिनिटी अपने मामा प्रधान भगत के घटनास्थल पर जाता था और वह अपने मामा के घर से ही अपने परिवार के साथ रहता था। दिन 22/6/12 को समय लगभग 3 बजे शाम मजदूरी करने के बाद रथ यात्रा के लिए वैसी ऑफ मनाने के लिए ट्रैक्टर से
जस्ट अ मिनट मजदूरी करने के बाद
रथ यात्रा के बासी और मनाने बसिलौटा मनाने के लिए पी खाकर नशे में ट्रैक्टर से मामा के घर जा रहा था। घर के बगल के जोमिडी गांव के सामने जैसे ही पहुंचा कि चलती ट्रैक्टर से उतरने के क्रम में वो ट्रैक्टर चालक का बिना बताए ट्रैक्टर से अपने गांव के सामने उतरने लगा और फिर गिर पड़ा और कुछ देर ही बाद मेरा लड़का बताने लगा कि पेट में दर्द हो रहा है और इलाज हेतु से मामा प्रधान एवं इतना सदर अस्पताल ले गया। इलाज के क्रम में उसकी मृत्यु हो गई। इट इज वेरी क्लियर दैट द इज traveling as a passenger of the tractor, Your Lordship, for celebrating the Rath Yatra, Your Lordship. As such, the disease was a gracious passenger, Your Lordship.
Now, how many witnesses are there?
Your Lordship, AW1, the wife.
Wife of whom?
Disease, Your Lordship.
The informant is the mother of the deceased.
मदर या फादर, Your Lordship. मदर और फादर देख लेते हैं।
Who is appearing for the owner? The counsel for the appellant argues the case. Full stop. Next paragraph. The owner of the vehicle, that is the respondent herein, has not appeared. Has not appeared in court today. Full stop. The name of the counsel appears in the cause list. Full stop. This case after 1 week. Full stop. It is made clear if the counsel for the respondent do not appear on the next date, this court may dispose of the appeal in their absence. That a copy of this order be communicated to the concerned lawyer.
Serial number 24, MA number 93 of 16, Mr. Amresh Kumar. For the appellant, Ms. Sushma Kumari, Mr. Lalan Kumar Singh for the respondent.
Yes, Mr. Amresh Kumar, what is this case? Unmute yourself, Mr. Amresh Kumar. Yes.
May order.
Yes.
That in this case, Your Lordship, for the I have already paid the amount, Your Lordship, as per Your Lordship's order, Your Lordship, and this appeal is filed on the ground of Your Lordship has the driving license, Your Lordship. The specific ground has taken by the appellant in the written statement that the owner or claimant has not filed driving license of the chassis state. And issue number 3, Your Lordship.
Yes.
Issue number 3.
There is no issue in respect of driving license.
Your Lordship, issue number 3 is there, Your Lordship.
Yes.
Covered the whether the claimants are entitled for compensation arising out of the motor accident. If so, to what extent and against whom of the office? That is the covered, Your Lordship. Whom of the office liability is fixed, that is under 149, Your Lordship. But learned court below has not decided this issue, Your Lordship. Decided only for this issue is deal only for quantum, Your Lordship, and in the last page it has only said page 9 of the and para 11. It is not disputed that the offending vehicle was insured with the OP number 2. And therefore, the OP number 2 become contractual liable and indemnified the claimants of the award. That's all. Nothing has said, Your Lordship.
Let us see your statement. What have you stated? Who is the owner?
Owner is not appeared, Your Lordship, in spite of paper publication, Your Lordship. And paper publication through police station, all effort has made, Your Lordship, but in the exhibit, Your Lordship, may kindly see the certified copy of FIR, exhibit 2, photocopy certificate registration, tax token, insurance, and postmortem. No DL, no permit, nothing. And also is not appeared, Your Lordship.
The license was there. You have got the number. So you say it is not verified till date. So when the number is there, at least you could say that whether it is a fake.
Your Lordship, it is not come in the judgment, Your Lordship, that the number is there, Your Lordship.
No. See.
Written state वो आगे
You come to
वो कुछ जमा करेंगे तभी ना हम कुछ देख पाएंगे.
paragraph 9 of the written statement.
9 of the
written statement, your written statement.
Yes, Your Lordship.
Read that.
Yes. That the driving license of the charge-seated driver, that is it now, issued by a Guwahati, which is still not verified until the verification of the said DL. No order may kindly be passed against the opposite party number 2.
So there is no statement to that effect that this DL is fake or the DL is not proper or.
Yes, Your Lordship. That is there.
Then what are the other grounds?
Your Lordship, may kindly take up this next week, Your Lordship. I'm not fully prepared, Your Lordship, for the LCR.
The learned counsel for the appellant submits that he has to go through the LCR.
Yes, sir.
LCR form which has been received by this court.
In physical mode.
The counsel for the appellant pays for some time and requests this case to be listed on the date when the court hears the cases physically. Whether allowed, is this case on the date when the court hears the cases physically?
I'm sorry, my lord. In item number 23, my lord couldn't connect, my lord.
Please don't interrupt. Once the board is over, you make a mention, or before I rise, you make a mention, whatever you want to mention.
Obliged.
Serial number 25, ML number 174 of 16, Mr. DC Jha for the appellant, Mr. Nikhil Ranjan, Mr. Uprakash Prasad for the respondent.
Your Lordship, if I may, Your Lordship, on behalf of Mr. Nikhil Ranjan, I'm praying for not today, Your Lordship.
Yes, why?
Your Lordship, actually, he's unwell since yesterday, Your Lordship. Due to that, he's not able to appear today, Your Lordship.
Mr. Jha, what is your ground?
Yes, Lordship. It is a case in which two vehicles has collided head-on collision, and drivers of both the vehicles has been charge-sheeted. One driver died during course of the accident, so the final form submitted showing him as dead, Your Lordship. But in this case, Your Lordship, the tribunal has wrongly held that the driver of the truck who was driving the vehicle and he died in the course of accident was not, he was not.
Prayer has been made on the ground of Mr. Nikhil Ranjan to adjourn this. Prayer has been made on behalf of Mr. Nikhil Ranjan that since he is not keeping well, this case be adjourned, full stop. Considering the submission, on the ground of Mr. Nikhil Ranjan, this case is adjourned.
Next week, Your Lordship.
Yes.
Serial number 26, with serial number 27, ML number 281 of 16, with ML number 341 of 16.
But in this case, I am appearing for the appellant in the first case. This is the second case, and the first case is for the enhancement, Your Lordship.
In first case, my lord, I am for the appellant Sunaina Devi. This is a case for enhancement, and second case by the insurance company.
Let us hear the insurance company appeal first.
Yes,
Your
Your
Lordship.
Lordship. Yes. In this case, it is a case of the insured claimant that he was traveling in the vehicle insured with us. He sustained injury. Thereafter, he died. Now, in this case, we have challenged the award on the ground inter alia that in the absence of any post-mortem report, whether the death can be said to have arisen out of the accident. In this case, it is very significant to note that the said accident took place on dates are very relevant, Your Lordship. 8/10/2005. 8/10/2005.
Yes, yeah. Yes.
8/10/2005 is the date of accident.
Yes.
Now, the injury report which they have submitted is dated 7/10/2005. And they say that deceased, he was admitted to RIMS. He died on 11/12/2005. Death certificate which has been issued from the RIMS Ranchi indicates that the deceased, he was admitted on 3/11/2005 and the cause of death is cardiorespiratory failure. Then in my respectful submission, Your Lordship, the said death cannot be attributed or has been arisen out of the use of the motor vehicle. Because
when was the FIR lodged?
But in the FIR, there is no whisper about the injury or the death or involvement of this deceased.
Let us see the FIR.
On the date of FIR, my lord, it was not possible to die on that day, my lord. And there is a judgment of this honorable court, my lord. They reported in 1998 that postmortem report in indicating the claim case is not that is Chudma Devi versus Arjun Urao, my lord. That is decided by Patna High Court Ranchi bench, my lord. If in the charge sheet the vehicle name is there.
There is Supreme Court judgment also, that is in 2018. Anil and others versus New India. That is reported in 2018 Supreme Court 612.
Just a minute.
Okay, my lord. Let the tell me.
2018.
2018 Supreme Court 612. Anil and others versus New India.
It is AIR.
Yes, AIR और सुप्रीम कोर्ट का इक्विवेलेंट हम देख लेते हैं, SCC देखते हैं.
What has been
SCC is there. 2018 Supreme Court 2018 Volume 2 SCC 482.
What has been held?
Now in this case,
2018 Volume 2 SCC page 482. Volume 2. Yes. What has been held in that judgment?
Yes, Your Lord, I am coming to that. I'm coming. The High Court noticed that there was no hospital records to indicate that from the nature of injuries, that death has occurred due to an accident in the nature alleged. The fact that the proper medical records were not available in this background weighed with High Court. I'm reading the paragraph 3. In appeal, the High Court has averted to a significant detailed number of disturbing facts which has emerged with the narration of the case by the claimant. High Court adverted to the relevant aspect in this. There is disturbing facts that emerged from the narration of the case by the claimants. In this case, the deceased was Ram Kanwar and his brother Satbir Singh, where the owner of the tractor PW1, Vishwant Shankar, who claims to be the eyewitness, state that he was along with two other persons, namely Rohtas and Ghanshyam, PW2, where the tractor driven by Dharampal. Ram Kanwar, deceased, was stated to have travelled in the said tractor also from Behrod to Shahjahanpur and alighted at Poladpur for some work and asked the driver to pick him up on the return. The tractor was returning. Now, that is the discussion. Significantly, no postmortem report was conducted. The High Court also noticed that the fact, though the accident took place on 12th January 1995, The complaint was lonely or lodged on 15 February 1995. As regards evidence of doctor, the driver, High Court noted that while at one stage he had stated that deceased was brought dead, at another place he stated and referred to the government hospital for further treatment. The circumstances that no postmortem was conducted is an extremely significant aspect of the case in our view has justifiably weighed by the High Court. Moreover, the High Court found that if there are three passengers in the tractor, all of them had known to the driver Dharampal by this negligent act, Ramavar I am covered, the most natural conduct would have been to lodge the complaint. The person who died in the was the brother of the owner of the tractor. Hence, the fact that the complaint was not lodged for nearly 1 month, it is significant omission on the case. The High Court nature of injuries that death occurred due to an accident or the nature of alleged. The deceased was conducting transport business, which other was an income tax receipt. The fact that a proper medical record were not available has this background weighed by the High Court. Besides the above aspect, the High Court has found that assessment of compensation tribunal is perverse. The reason is that for this above we have find no reasons. The appeals are doubly dismissed. There shall be no orders to cost. So here also, my lord, the injury report as per the record which is available to me is 7-8 and 7th accident as I have taken on 8. He was readmitted to RIMS on 13th 11 3/11, died on 11/12. So therefore, your lordship, how this injury can be attributed to have arisen out of the accident of the use of motor vehicle, because there is no postmortem report also. It is an injury that is death certificate, death due to cardiorespiratory failure.
Kindly see, my lord, para 10 and para 11 of the impugned judgment, my lord.
Read the FIR first.
FIR. My lord.
Yes.
FIR. In this case, my lord, सेवा में सीमांत थाना प्रभारी पीथर थाना वहां से निवेदन है कि मैं मित्रजीत पांडे पिता स्वर्गीय गंदौरी पांडे साकिन पालगंज महादेव डी थाना पिताड़ इतना 6:30 बजे संध्या हमारा भाई रामेश्वर पांडे पिता गंदौरी पांडे साकिन पालगंज महादेव डी थाना परिताड़ जिला गिरिडीह कमांडर जीप नंबर JH10A4574 से पीरताड़ से अपने घर पालगंज महादेव डीप जा रहे थे। जैसे ही ग्राम पत्थलघटिया के पास पुल के नजदीक 6:30 बजे पहुंची कि गाड़ी सड़क के दाहिने तरफ उलट गई, जिससे मेरे भाई का घटनास्थल पर ही मृत्यु हो गई। वहां के प्रदर्शनियों ने बताया कि गाड़ी काफी तेजी लापरवाही से चला गया था। दुर्घटना में 4-5 और व्यक्ति जख्मी हुए हैं, जिसका इलाज गिरिडीह अस्पताल में हो रहा है। मैं उन 4-5 व्यक्तियों में से हूँ। यही है मेरा कहना, मेरा माय लॉर्ड। ये और इसके बाद जो चार्जशीट जो हुआ,
no, who is the deceased?
Deceased is my lord शंकर लाल बर्नवाल। जो 4-5 व्यक्ति जख्मी में उनमें से मैं बर्नवाल है। इसमें जो चार्जशीट जो हुआ है, इसमें डॉक्टर भी एग्जामिन हुए हैं जिम्स के और भी
Just a minute.
10-11
Just a minute. So the informant's brother died on spot and the others got injured.
Yes, my lord.
So what are the medical documents? Let us see.
Injury report at Giridih, that is dated 7/10/2005.
Where is it? An exhibit?
Exhibit 20.
20.
21. The injury report.
Just
Refer to rims.
Exhibit.
Thereafter, the death certificate. That is very significant, Your Lordship.
Just wait, just a minute. Let me go through it. Yes.
And certain documents have been filed by the insurance company also.
Exhibit 18. Then where is Exhibit 19 and 20? It's not here. What is Exhibit 20?
Is the certificate of rims. It clearly says date of admission on 3/11/5.
Just a minute. Exhibit 20. This is a certificate.
Yes. Now, if we go through it, it says the date of admission is 3/11/2005, meaning thereby, after the said injury, he was discharged and readmitted to RIMS. Therefore, how this death can be attributed to the same accident? There cannot be any close proximity with it. He was released, then readmitted. Might be for some other reason.
A doctor has been examined in this case. That has been discussed in para 10 and 11, my lord, of the impugned judgment.
Well, where is the other medical reports? The doctor, if has been examined, doctor must have has prescribed, diagnosed. There may be a daily bedhead ticket. Where are those documents?
May I go through para 10, my lord?
Read para 10.
Para 10, my lord. I have also perused the evidence of the oral witnesses and find that CWC Sunny Kumar Barnwal has claimed to be eyewitness of the occurrence, and according to him, he was boarded in another vehicle on the same road. Commander Jeep bearing such and such overtook his vehicle and thereafter, my lord.
Injured.
Yes, my lord.
What was the injury? Tell me what was the injury?
Injury, my lord, fracture of the spinal cord, etc., my lord. And therefore,
there is only one. There is one simple injury and a grievous injury. There are two injuries.
That has been discussed, my lord. Kindly see, my lord. CW4 also stated same person stated CW6. Dr. Alok Kumar, who has examined Shankar Lal Barnwal, also came and deposed in the court that on 8/10/2005, he examined Shankar Lal Barnwal and he found complaint of pain on both sides of pelvis and pain dorsal-lumbar region, and he was advised for X-ray. This witness has further stated that he received supplementary injury report from which he found that X-ray shows comprehension fracture of dorsal-lumbar region at the level T12 and L1. As per his evidence, patient was referred to RIMS for further management. This witness has proved the injury report and has been marked as Exhibit 17 and 18. According to this witness, also such type of injury may be caused by motor vehicle accident. This witness has further stated that due to compression fracture, the death may be caused. At this juncture, it is further important to mention here that insurance company did not cross-examine this witness.
On what basis? On what basis? Where is the death certificate?
The death certificate is there, my lord.
He says that due to
postmortem is not there. Postmortem, it has been discussed in para 11, my lord.
Yes.
On basis of the above documentary evidences as well as oral witnesses, there is no hesitation to hold that deceased was traveling as a passenger on 8/10/2005 and he got injured. Now the second question comes for my consideration as to whether death of the deceased was due to the said injury. There is no denying of this fact that postmortem report has not been brought by the claimant. Claimant has brought death report of Sankalal Banwal is exhibit 2. On its facial, it appears to me that place of death of deceased was IMS Ranchi. I have already discussed in my preceding paragraph that deceased Sankalal Banwal received injury in the said accident. I have already discussed that after receiving injury and after treatment, he has been referred to RIMS for better treatment. On basis of Exhibit 2, death of deceased took place at RIMS. No doubt, as per Exhibit 1, cause of death of the deceased has been mentioned as cardiorespiratory failure. As per evidence of CW6, patient may have died due to compression fracture. I have already discussed the evidence of doctors who find compression fracture of dorsolateral region of the deceased. Exhibit 20 and 21 establishes this fact that Sankalal Banwal admitted at RIMS on 3/11/5 and remained there up to death, that is on 11/12/2005. On a careful scrutinizing the documentary evidences and oral evidences, it appears to me that cause of death of the deceased was a cardiorespiratory failure. On basis of the entire evidence, there is no doubt about that deceased has suffered a grievous injury such as compression fracture of lumbar region, and as per doctor's evidence, it may cause death. Hence, I am of this opinion that in this case, there is a clear nexus of fracture of dorsolateral region of the deceased with his death. I come to this conclusion that death of the deceased was due to the accident which took place on 8/10/5. I negative the contention of learned counsel of the insurance company. The witness was not examined by the insurance company, my lord. That is also very good.
I have understood. Now tell me one thing. This doctor has referred the injured to RIMS. When?
My lord.
When? When?
I will go through the evidence, my lord.
Yes, when?
Can you allow me 1 minute time, my lord?
Yes.
A day before the alleged accident, as per the injury report.
Doctor's examination on oath. Yes. On 8, that is witness number 6.
Yes.
On 8/10/2005, I was posted at Sadar Hospital, Giridih as medical officer. On that date, I examined Sankalal Banwal, son of Anandlal Banwal of Argha Ghat, PS Town, district Giridih, at 7:10 a.m. and found the following. And detail of has been mentioned. Patient was admitted, referred to surgeon for further management. The above injury carried by caused by hard and blunt substance and between 12 hours duration. Mark of identification. Supplementary report was received.
Mark for identification. Just a minute. Mark for identification.
Till on chest. Mark of identification till on chest.
Okay. No. What is the document he's exhibiting?
Supplementary report was received on 17/10/5. Opinion was given by Dr. R. Hemzam, Sadar Hospital, Giridih, and given the opinion regarding injury number 1. He was opined that both side pelvic bone normal, so injury simple. He has also given the opinion regarding injury number 2 that he has found compression fracture of dorsolateral region at the level of T12 and
so this
L1.
This is on 8/10/2005.
17/10.
No. The first.
After supplementary report.
First. The
First was, yes, my lord.
first is 810.
Yes, my lord.
810. First report, that is Exhibit 17 by 1.
My lord.
Then the supplementary report on
1710.
17/10/2005.
Yes, my lord.
That is Exhibit 17.
My lord.
Now show me the medical treatment reports, records, or anything of RIMS.
Yes, my lord. That is Azim's. That is, my lord, exhibit 20, certificate of Zims, exhibit 2021.
Date of admission may kindly be seen.
Just a minute.
Date of admission RIMS may kindly be seen.
Just a minute. Mr. Lokal, just wait.
Yes, yes. Now we are afraid, when Mr. Arlal is appearing.
Exhibit 20. Mr. Lal?
My lord.
Exhibit, you are referring to exhibit?
20, my lord.
Exhibit 20. That
Dr.
is
C. report.
that is 4/4/2000.
6. That is certificate.
Fourth bill.
That name is rectified.
Or the name, what was the earlier name?
It can't be 6 because he has died in 2005 itself.
Name is actually as per the affidavit में notary public. And then
Name is rectified as per the affidavit 225 or 2.
Shankar Lal Barnwal, Shankar Prasad Barnwal. That was the difference.
Shankar Prasad Barnwal and Shankar Lal Barnwal.
Yes, my lord.
Just a minute. You have been admitted on 3/11/2005.
5. The date of accident is 8/10/2005.
Where are your documents of treatment in RIMS?
Documents that are in the record of this my lord, insurance companies. They have also filed certain documents, my lord.
How those records can be in our possession, sir?
Exhibit A to Exhibit A to 5.
What are these? These are same thing which you have filed.
Yes, my lord.
How those can records be in our possession?
Just tell me, you have been admitted on 3/11/2005.
Yes, my lord.
And your death is
11/10.
After the
11/12.
11/12/2005.
My lord.
Show me your treatment in RIMS. You underwent any operation of the spinal cord or any other things or any, then I could understand that yes, it is related to the accident. Some doctors saying that this can be the death, this can cause death also, it's not enough.
But the accident is not denied, my lord. Treatment is not denied, my lord.
Accident and treatment not denied, that doesn't mean that the death arises out of the accident. The injury may arise out of accident. You may,
My lord, but when doctors were under a cross-examination, the insurance company has not cross-examined him.
not necessary. Not necessary. Is that the doctor who had treated you? Is that the doctor who can, he's a person who can say the reason of death, cause of death? Is that a correct person?
He was the first doctor.
He was the first doctor. He found only there's some fracture. Yes. And that too, he has referred with what? What is the referral? What is the writing there in the referral letter? He is being referred to so-and-so for better management.
My lord. Oh, then I will verify, my lord, from the records.
The accident had taken place. There is no doubt about the accident.
My
There is no doubt that you were injured.
My lord.
But whether you died of that said injury or the accident.
But in the trial court, my lord, the insurance company has not denied. He has in the appeal that the first time they are denying that they are challenging the nexus.
Have they accepted that yes, the death is because of that injury? It is you who have. It is you who have.
I will allow some time, my lord.
You may get compensation for the account of injury sustained, but not for the death.
But he sustained injuries, and injuries are there, my lord. And for that treatment, he has been admitted in RIMS, my lord. There is no other disease.
Show me for that treatment he has been admitted in RIMS and he was admitted. Suppose the RIMS document, listen to me. Suppose the RIMS document shows that he was only treated for heart disease, then tell me.
That may be said, my lord. So I may be allowed some time, my lord, to verify all those documents, my lord.
So how can you verify all those documents when the documents are not there? You have to verify only what are there in the lower court records.
Yes, kindly allow me some time, my lord.
May I submit one thing, Your Lordship?
Yes.
The discharge summary of the RIMS is important, Your Lordship.
He was not discharged. He died during the treatment.
The discharge certificate, he died. He died in RIMS.
He was admitted on 3rd of November. Accident is on 10th October. Whether he was admitted for the same cause or for other cause.
Whether Mr. Arvind Lal, if the situation was so serious and you have been referred to RIMS, he would have been admitted to RIMS the very next day or the day after. So how do you explain this gap, of this long gap?
Let me verify from the records, my lord, and from my client how it happened, my lord. Very important question my lord has raised.
Mr. Arvind Lal prays for some time to verify the records. They are allowed this case after 2 weeks?
After 4 weeks, my lord. Because they are in villages unable to contact over phone every time.
My report was not on 15,
Or maybe 3 weeks. Maybe 3 weeks.
They're in the town, in Giridih, Mr.
But my repair will be not on 14th and 15th, Your Lordship, on March. After that.
After 3 weeks, let's see.
Because I will not be here on 14th and 15th, Your Lordship.
See, if you're not there, how are you apprehending when this case will be listed? If you're not here, your associate counsel will pray for time.
Okay, then.
Serial number 28, MN number 373 of 16, Mr. P.K. Mukhopadhyay, Mr. Dhirendra Kumar Prasad.
Due to oversight, Your Lordship, I could not file the Wakalatnama. My Lord, I'll be filing it today. Let it come in the next week. I could not file the Wakalatnama. I've noticed it only.
Wakalatnama has not been filed on behalf of the insurance company. So stop. Alok commits that he will file Wakalatnama within 2 days. By this week. Within this week. We'll stop. Let's discuss next week.
Yes, sir.
Serial number 29, MN number 380 of 16,
May I please, my lord? My lords, before my senior Mr. Ekela submits anything, I may be permitted to submit one line.
Yes.
He has filed one cross objection in this case. He is submitting that both the cases be listed together. I have no objection to that. Only one prayer is that, my lords, there is stay petition pending since 2019. I have been informed on Friday that, my lords, the executing court has given, my lords, they are pursuing hard for the deposit of the amount. We will deposit the amount, my lords, may kindly grant me stay, my lords.
If you do, what stay?
Stay of execution case, my lords. IN number 11779 is already on record, my lords.
What is your ground in this?
There is ground of, my lords, quantum. The deceased was the claimant.
Only quantum?
Yes, my lords.
You want for reduction of the quantum and he prays for enhancement of the quantum.
Yes, my lords.
Number?
11779 of 2019, IA.
1177? No. The cross objection.
Cross objection number, not he will give. He has served me a copy in which number is not there. I'll give that number. Just one moment.
I've not got the number till date, my lord. I have verified.
No. I am giving the number, my lords. I am giving the number. But by my lords may kindly appreciate, my lords. We will deposit the whatever direction is there. Will comply with that, my lords. For my sake, it may kindly be stayed, my lords. But on Friday, I was informed that my lords executing court will issue some.
Mr. Lal, give me the number, objection number.
I have not got me because.
When have you filed?
Mr. Manish Kumar is having the number, my lord.
When have you filed?
I have filed a few months back, my lord. But since my clerk has not come, therefore I am not able to test my file today, my lord. Therefore, I am sorry, my lord.
I am giving the number, my lord.
Yes.
It is CO number 33 of 2021. In 18, notice was issued, and he has filed in 2021. That is a different issue, my lord. We will argue when cases are listed. But so far as this stage is concerned, my lord, I am ready.
List this case along with cross objection 33 of 2021 filed by the claimants. So this case should be listed next Monday?
Yes, my lord.
Under the heading for admission.
Yes.
Mr. Lal, will you pursue the execution case till Monday?
If my lord may say that, then I will not pursue. But the court has passed certain orders, my lord, there.
What are the orders? What are the orders which has been passed? Tell me.
I am not aware, my lord, because I am not in contact with Dalton, the advocate for the last few days.
What are the orders which have been passed?
No, I have been informed that, my lord, the court will now proceed with, my lord, seizure of bank account and all the forfeiture of bank account, my lord. Therefore, I was saying, let it be stay for 1 week, my lord. Let it come on Monday. I will, my lord, assist your lordship, my lord.
It is expected that the executing court, who is in session of execution case number
36 of 2016.
36 of 2016, arising out of
MV claim case number 16 of 2014.
Case number
16 of 2014.
16 of 2014 will not proceed.
Yes, madam.
till next date of hearing of this case, of this appeal.
Monday 6 Monday.
Monday.
Online.
Monday.
Online.
Mr. Arvind Lal, Mr. Arvind Lal, just see if there are any defects in the cross objection. If there are any
Yes, my lord.
defects in the cross objection, try to remove them.
Okay, my lord.
Serial number 13, MA number 396 of 16, Mr. M.B. Lal, for the appellant.
My lord, I am appearing on behalf of appellant, my lord.
Yes.
In this case, my lord, the claimants are the mother, father, and siblings of the deceased, my lord. The deceased died on 1/1/2006. He was having a business of selling chowmein, eggs, meat shop on Thela, and used to earn rupees 9,000 per month. Below this case was filed under section 163A of Motor Vehicle Act, Milord. And Milord, the learned court below has under the structural formula second schedule of MBA has assessed the income, notional income of the deceased as 1,000, 15,000 per annum, Milord. And uh, altogether 1,64,500 has been awarded along with 9% interest from date of award, my lord. My lord, in the deposition, the mother of deceased has deposed that her son was doing business of fast food on Thela, whereas the father of the deceased had deposed that he was a loader. And my lord, the code below
LCR.
on the oral.
LCR. Your argument cannot be appreciated without the LCR. It is coming under the LCR is here. Yes. Yes.
My lord, finding the oral evidence are contradictory on nature of work by the deceased. The court below has recorded in its finding that the deceased was doing nothing prior to his death.
Mr. Counsel, if there is some discrepancy in the evidence which led to a wrong finding, then don't read that finding, read the evidence. So that I can.
My submission is that in any case it can be presumed that deceased was working and earning earning member of his family, my lord.
You show me, go through the evidence. You say there was a contradiction in the evidence of both the witnesses, and the court has wrongly has wrongly appreciated the evidence. Is it your case?
My lord.
So if that be so,
my lord,
then
on point of
you read the evidence. You read the evidence.
my lord, इसको एक सप्ताह के बाद रख दिया जाए. I have to go through the evidence, my lord.
What is this? What is this sort of prayer? You people are not ready. You are not ready with the papers. This is not proper, Mr. Counsel.
I apologize for this, my lord. I sincerely apologize.
During the midst of the argument, learned counsel for the appellant submits that he is not ready with the entire papers and documents. You don't have a copy of the depositions.
Deposition is with me, my lord, but it is not in the file, so I have to find out. In fact,
it is with you or it is not with you. It is with me. It is not in the file. This is not an answer.
My lord, yes, my lord.
Is it with you? If it is with you,
Right
open
now
the
it is.
start reading.
Right now it is not with me, my lord.
Then where it is? He submits that he has to refer to the depositions, but the copy of the depositions are not with him. He prays for some time. Without having any other alternative, this case has to be adjourned on the aforesaid prayer. This is adjourned for 2 weeks.
Obliged, my lord.
Serial number 31 with serial number 32, MA number 412 of 50, with MA number 335 of 50, Mr. Alok Lal for appellant in first case with Mr. Naresh Prasad Thakur and Mr. Arvind Kumar Lal for respondent first case. Mr. Suraj Jogunda, Mr. Anil Kumar Singh, appellant in first case, Mr. Santosh Kumar, Mr. Arvind Kumar Lal for responding in second case.
But subject to correction by your lordship, Sir Lord. In this case, then this matter was taken up 11/8/2021 by learned adversary has taken time to provide the details of the ownership of the tractor. Subject to correction, your lordship, as per my record.
You have 4.
No, your lordship, Mr. Lal, Arvind Kumar Lal.
Email number 412.
412. These are the analogous matters. One is for as usual for enhancement.
Yes, Mr. Arvind Lal.
My lord, I have sent information to my client, my lord, but he has not come. Perhaps his villager has said that he is ill. Therefore, I'm not able to contact further, my lord.
Mr. Arvind Kumar Lal will seek instruction and inform as whether the tractor in question is still in possession of his client. So he prays for some time. Does this case after 3 weeks?
2 weeks. 3 weeks.
3 weeks.
No.
Serial number 33, MA number 468 of 16, Mr. Alok Lal for the appellant.
In this case, we are challenging the liability on various counts. The first and foremost would be.
Yes, what are the counts?
Yes. At the dead of the night at 2 a.m.
Yes.
The deceased, he was crossing the road to attend the call of nature.
Yes.
And in that course, he was run over by the truck insured with us.
Okay.
In this case, it is significant that in paragraph, we have taken a defense with regard to the validity of the documents pertaining to the vehicle. Now, in this case, what has happened, kindly come to the issues. No, just a minute, Your Lordship. There is something confusion, Your Lordship. Just a minute, Your Lordship. I have taken the other file. Just a minute. Yes. Now, he was crossing the road. Now, in this case, we have taken a defense of invalid driving license. Kindly come to page issue number 4, which would be first of all paragraph 8 of the paragraph 8. In my written statement, we have taken the ground of invalid driving license. Now, subsequent thereto, the issues have been framed. That is issue number 4.
Just a minute. Let me see your written statement first.
Yes. Paragraph 8 of my written statement.
What is the nature of denial or assertion? Yes. Paragraph 8.
Yes. Page 2, sub para. That is sub para. Just paragraph 9. 8 is part 2. 8 part 2.
So they have not filed the the driving license.
Owner has not appeared even. Now, taking into my account my pleading,
Yes.
the tribunal has framed issue number 4.
Issue number 4.
Yes.
Yes.
That is at page 7.
Where is the dealing with issue
Very
number?
significantly, Your Lordship, kindly come to the discussion with regard to this issue.
Where is it?
That is what I am submitting. This is what I am. This is the. It has not been discussed. Rather, in paragraph 10, which is spilling over to page 11.
Just a minute.
This is the discussion. Paragraph 10, last few lines. Sorry, paragraph 11, last few lines. Spilling over to page 13.
Yes.
I'm reading it. In Messrs. National Insurance Company Limited, but in fact, it is tried to deny the shifting liability of burden over the shoulder of the defendant number 2 owner. In this context, it is safe that defendant number 1, who is a duty bound to produce all those relevant documents of the truck and the individual insurance policy, and this defend that so that the defendant number 2 would have been able to get it verified from its office. But as per its record, neither nor has she has appeared to nor furnished. Now, this finding is there, this is observation is also there. Thereafter, instead of giving an adverse inference or any finding on the issue number 4, nothing has been said simply because the insurance company was liable. Therefore, the insurance company has to pay, and moreover, the future prospect, the age of the deceased was 55 years. Future prospect has been added to the extent of 50%. Now, on the point of contributory negligence, if a person in the dead of the night is crossing the road, he should also be very.
So can there be a ground to conclude that he is also responsible?
To certain extent, you also a person to the dead of the night.
Evidence. What is your evidence? What is your evidence?
There is no evidence. There is no evidence of mine, but the normal presumption will show.
Come to the main issues. Don't harp these irrelevant points. Now let us see. Let us see the documents.
Oh yes, let the FIR would be evident in this case.
What are the exhibits? Let us see the list of exhibits. FIR, charge sheet, postmortem report, place slip, photo ID card. Where is the charge sheet? Let us see the charge sheet.
The charge sheet is certainly against me.
Against you? How it can be against you?
Against the my insured vehicle.
Let us see the charge sheet. Whether in the
my insured vehicle.
Any whisper about the license? Where is the charge sheet? Is exhibit?
But normally the charge sheet will not indicate the driving license. But the thing is that
I want to see there is nothing normal, abnormal. I want to see it is there, yes or no. If it is yes, the conclusion will be different. If it is no, the conclusion will be.
But in charge sheet, normally the vehicle,
no, just where is the charge sheet? Let us see. It is yes or no. There is nothing called normally, abnormally. So if you say that normally it is not there, abnormally in some cases it can be there also. So let us see the charge sheet itself.
Yes, Your Lordship. Who is appearing for the claimant? Mr. Lala is perhaps appearing in this case, but I do not know.
Mr. Arvind Lal.
No, Mr. Pratyush Lala, the name is appearing on Mr. Pratyush Lala.
My lord, I am appearing on behalf of the claimant. My lord, Mr. Pratyush Lala is arguing in some another case, so I am here.
Who is for the owner?
Status of notice. The notices were issued, Your Lordship, but I am not aware of the status.
This is the only ground which we're taking?
That only the right of recovery should have been given because of the non-protection.
And the license.
Yes. But one thing out of context, my lord, we have got the supervision note. In that supervision note, it has come that deceased, he was sleeping after having a liquor, and all of a sudden he came to the road. But that cannot be a ground.
Note is not an evidence.
No, that is not an evidence. That is what I am submitting. This is the out of context. That is what I very outside I said is out of context.
Now let us see what about the service of notice upon the owner. Owner is respondent number 2.
Owner is respondent number 2, Indrajit Kaur.
So it is validly served. Yes. Now claimant, tell me.
And future prospect has been at 50%.
This is the only ground. Yes.
Yes, my lord. Learned counsel is appearing in another court.
I don't know. He may be appearing in another court. I am least bothered to argue. I have already heard the matter. One side has finished his argument. Argue. What do you have to say about the driving license? The judgment you are referring to, Mr. Loklal?
Yes, sir.
What is the judgment you are referring to? Violation of policy?
That is Pappu versus Vinod Kumar Lamba.
Reference?
I'll give the just a minute. Just a minute. And my lord, in this case, the interest, earlier this case was filed before the permanent Lok Adalat. It was withdrawn. Thereafter filed before the claims tribunal. And the interest has been imposed right from the day when it was filed before the permanent Lok Adalat. Whether such order can be sustainable for payment of interest. Of course, Vinod Kumar Lamba.
Claim petition was filed in 2010.
Yes, and
yes,
it was filed before the PLA.
Maybe, but this is the, as per MV Act, interest has to be paid, but not before the date of filing.
Yes.
So the date of filing is 2010. How can it be from 2007? Interest.
This is what the tribunal has said. This is what the tribunal has said.
Yes. Pappu, give me the reference.
Yes, my friend is giving it. That Pappu is 2018 volume 3 SCC 208.
2018 volume 3 SCC 208.
208.
So you have nothing to say, Mr. Counsel? Respondent?
My lord, so far as per 2007 is concerned, I have complained, respondent number 1 has filed Bagmara Mahuda PS case number 2014/2007. So far, the learned court below has observed that date, my lord.
Just tell me, he has raised 3 points. Number 1, DL is not there, not produced, and there was an issue to that effect. Issue framed, so that issue had to be answered.
Yes, my lord.
Number two, the issue was not answered. The point number two is 50% future prospect, which is not proper as per Pranay Shetty. Number three, interest cannot be levied prior to the date when from a date when the case was filed.
Yes, my lord.
What do you have to say?
Yes.
One more that Amrit Paul Singh versus Tata AIG, that is also on the same issue.
Yes.
2018 volume 7 SCC 558.
What is this?
Amrit Paul Singh versus Tata AIG in General Insurance Company Limited.
187558. Amrit Paul Singh.
187,558.
(18.3) and 18.7. Yes, Mr. Lala. Answer these three issues. First, answer his argument that the claim case was filed in 2010 and the interest has been awarded from 2007. Unmute yourself. Unmute yourself. If you file a claim case before a long forum, can it be said to be a proper filing? You withdrew that, then you file here before the tribunal. So can you get benefit of that period? Interest is governed by section
171
of the Motor Vehicle Act. It specifically says interest can be granted, but it should not be from a date prior to filing of this application. What is your argument?
मतलब इसको 2010 से ये जो कर दिया जाए, 2010 से तो मिलेगा ना?
100%. Now the second question. Now the second point. As per Pranay Shetty judgment, you are not entitled to receive enhancements to the tune of 50%. The age of the deceased is
55 years. 55 years.
55 years. So it should be how much? Where is the Pranay Shetty chart?
50 में आ जाएगा परमानेंट है परमानेंट 50 की ऐसे 15.
It will be perhaps subject to correction, or it will be 15% perhaps.
It will be 15% since he was a permanent salaried job.
Yes, that I am not disputing it.
It will be 15%, not 50%, Mr. Lala.
Yes, Lord.
This is his argument. What do you have to say?
Yes, my Lord.
And we have deposited 17 lakhs.
Just a minute. Yes.
Well, he has deposited 10 lakhs only by virtue of the order of this honorable court.
7 lakhs is also there.
That is on the main. You
Achha.
You tell me. You answer this. His argument. You counter it. He says it will not be 50%. It will be 15%.
Well, 2 weeks time, if possible, may kindly be given on this. ये तो पढ़ने वाला वो तो जो लिखा हुआ उसमें तो टेबल बना के लिखा हुआ है जजमेंट में कि 15%.
So 15% you have got no objection to this?
Yes, my lords.
What was the conventional and how much has been paid? $1,50,000, 2 lakhs.
More than 2 lakhs.
2,10,000. What do you have?
10,000.
What do you have to say to this, as per Pranay Shetty? Tell me.
इसमें जो हमको 2 सप्ताह का समय दे दिया जाए, जो हम बता दें।
कितने का दिया? कुछ कितना मल्टीप्लायर जो है
2 सप्ताह का जो समय दे दिया जाए, जो उस दिन जो होगा हम कंसीड कर जाएंगे जो रहेगा।
And the last point is driving license. Issue number 4 has not been answered. That prima facie I feel will not affect you, because at best the insurance company get a right to recover the amount after paying the same.
But the amount, if it hasn't paid and in excess, then they have to return it.
And their amount has been paid.
Yes, 10 lakhs we have paid in pursuant to your lordship direction dated 9/4/18, and 7 lakhs is draft is ready there. 17 lakhs we are directed to pay. 10 lakhs has been disbursed to them.
What is the income of the deceased?
That is
not disputed. He was a permanent employee, so
how much?
9,500. 834 rupees.
Whatever it may be, we are not disputing it.
What is the
not disputing it. And deduction is also 1/4.
Yes.
It should have been 1/3, your lordship, because the wife is the only claimant.
How many dependents are there? Claimants have been.
As per the claim application, there is only one, Surji Devi.
Yes. So if there is, it should be 1/3.
It should be 1/3. Others have not been added as a party, even if they are.
What is the multiplier?
Multiplier
11. 11.
11 होना चाहिए इसमें।
11 होना चाहिए ना?
11 ही से किया गया।
11 किया है।
टेबल का 7 देखा जाए, पेज 15 का टेबल का 7।
11 ही है इसमें, कहीं कोई दो हम डिस्प्यूट नहीं कर रहे हैं। और इंटरेस्ट 9% अवॉर्ड किया गया है।
2010 is the date of accident.
Yes, Your Lordship.
Is the filing of a claim application.
Date of filing of the claim
Date
application.
of accident है 3 of October
Claim-
2007.
Claim application.
Claim application 2010 का है.
It was filed when? When? Give me the date.
I can tell it from the notice which we have received. The notice where well, there is no date in the notices which we have received also. But it is 163 of 2007 that we can
178 of 2010 है. Title
163 ना है 163 और 7 है subject to correction. मेरे पास वही नोटिस है
178 by 2010.
इसमें जो हफ्ता का टाइम मिल सकता है.
How much you have paid? 10 lakhs.
10 lakhs plus 7,000. Two checks we have deposited. 10 lakhs was to be disbursed to them. 7 lakhs is perhaps still awaiting there, pending there. And 25,000 here as a statutory deposit.
According to the calculation, keeping the interest rate as what has been granted, it comes to 16 lakhs 40,000 800. 16 lakh 41,000. Yes, Mr. Lal.
We're at 16 lakhs 14,000.
40,000.
40,000. That is with regard to when 50% has been taken into consideration.
Oh, no. I have calculated it.
Well, then I will check the calculation because there is some appears to be some error because if those things are taken, that comes to that amount is taken. That is coming to 14 lakhs.
Oh.
Kindly see if the figure which has been given by the learned tribunal, the award of component of award is 40,35,000.
No. My calculation is along with interest.
Is along with up to what? Up to which date?
Till the date of the award.
Till the date of the award. So the interest rate is also is high because 7.5% is the rate of interest which is being awarded because 7.5% because no banks are awarding interest on their deposit more than 4%. But the Lordship in several judges has held that 7.5% and that is where the uniformity has been made 7.5%. Therefore, that should also be taken into account.
No. 9%. According to me, it comes to 16 lakhs 41,000 to round up, along with interest. Principal is 10 lakh 65, interest is 5 lakh 75.
I have not, that may be correct, because I have not many calculations. I have not made calculations.
Yes, next week you want Mr. Pratiflala.
Yes, Lordship. वो जो उसका लास्ट में जो जजमेंट का ये कोट कर रहे हैं पैरा 61 का, उसमें जो कुछ ऐसा भी डिडक्शन है जिसमें हमको कुछ कम मिला है, उसको हजूर हम अच्छा से स्टडी करके।
कैसे कम मिला है, किसमें कम मिला है?
हाँ, जैसे लॉस ऑफ ये
किसमें कम मिला है?
हाँ हाँ बोल रहे रोमन 8 में आया जाए, रोमन 8 में 1029 पेज जो है, रोमन लास्ट पैरा 61 का लास्ट में, पैरा 62 जो है,
पैरा 62
ये जो जजमेंट जो कोट कर रहे हैं,
यस,
प्रिया सेठी वाला,
शेट्टी, यस, रीड
सब लास्ट में रोमन 8 रीजनेबल फिगर ऑन कन्वेंशनल हेड नेमली लॉस ऑफ स्टेट, लॉस ऑफ कॉन्स्ट्रक्टम एंड funeral expenses should be 15,000 rupees, 40,000 and rupees 15,000 respectively. The appropriate amount should be enhanced at the rate of 10% in every 3 years.
So from when? Enhance from when?
इसीलिए जो हम एक सप्ताह का जो
Enhance from when?
From the date of the application.
No. How can your funeral expenses increase, which has already taken place? It is every 3 years from the date of the judgment, that particular judgment of Pranay Shetty. And over here, you have been paid 2,10,000. As per Pranay Shetty judgment, you are only entitled to receive 70,000. When the accident is for the year 2000, what is the date of accident of Pranay Shetty? Go to the first paragraphs. What is the date of accident which was dealt with in the Pranay Shetty case?
एक सप्ताह का जो समय दे जो पढ़ के बोल रहे हैं।
Here, Mr. Alok Lal has argued the case on merits. Full stop. The respondents thereafter prayed for some time to answer to rebut the arguments which have been advanced on behalf of the applicants. This is next week for, if possible, to be disposed of finally. Now, in the meantime, the lower court records be called for. To special lower court record be called for immediately through special messenger. Full stop. The office is directed to send fax immediately so that the lower court can send the same, so that the tribunal so and so can send the same before this appeal is again taken up. Don't pray for any time on that date.
Yes, Lord.
Serial number 34, MA number 476 of 16, Mr. Manish Kumar for the appellant, Mr. Sabyasachi for the respondent.
May I please, Your Lordship?
Yes.
Your Lordship, in this case, on the last occasion it was heard, and Your Lordship, Council for the Insurance Policy, Your Lordship, they have stated that the person who has died was the gratuitous passenger, so liability should be shifted upon the owner, Your Lordship. Your Lordship, I am denying this fact, Your Lordship. The person who has died, he was the cleaner, he was the khalasi, Your Lordship. And same has been stated in para 2 of the judgment itself, Your Lordship, on the face of the 8 Your Lordship.
Mr. Sabyasachi,
Lordship.
This is an appeal. What is the finding in the judgment is under challenge. So read the evidence pleadings.
Regarding that, Your Lordship, I have to peruse the lower court record, Your Lordship. So, if possible, Your Lordship, then it will be.
Show me the LCR. Who are you?
I'm the owner, Your Lordship.
You have filed the show causes?
I have not filed, Your Lordship.
Hmm? You have not filed the show cause.
Till today, I have not filed, Your Lordship.
Para 5 of the impugned order, my lords, contains the pleading of the owner, my lords.
What is the name of the owner?
Four and five, Your Lordship.
Who is the owner of the vehicle?
Dhanurjay Mahto and Ghasi Ram Samad.
Dhanurjay Mahto and Ghasiram Sama. Yes.
Ghasiram Samad is the driver, my lords.
Driver Mahendra Mahto and
Dhanurjay
Dhanurjay
Mahto. 3 and 4, dependent number 3 and 4.
Mahto.
They have not admitted that they are the employer. You yourself has filed. You yourself has not admitted.
Your Lordship, it has been stated that in absence of any documents, Your Lordship.
You are the owner.
Your Lordship.
So you deny. You have not admitted that you are his employee.
But Your Lordship, it is a fact of the case.
No, no. How can you allow to take a diametrically opposite stand in this appeal, which you have not taken in your written statement?
Regarding that, Your Lordship, I have to see my reply and all. Let it be in after 2 or 3 weeks, Your Lordship.
Why these cases are being listed unnecessarily?
So he has taken time twice, my lords.
Only once, not twice.
Not interested in arguing the cases.
Only once I have taken time, Your Lordship. Thereafter, Your Lordship, court was closed, Your Lordship, so I could not.
So court was not closed.
Means, Your Lordship.
It was in the virtual mode.
Your Lordship. Your Lordship.
It is your case that he was not the owner, your employee. Finished. Finished.
Both tractor and trailer was insured, Your Lordship, and
maybe, but
and the person who has died, he was the cleaner.
That is not your case.
Your Lordship.
How can you say that?
As per para 5 of the impugned order, Your Lordship.
Mr. Sabyasachi, you have to stick to your statement or your argument made in the written statement.
Your Lordship.
And in your depositions. You have not deposed as a witness?
They have appeared, but whether they have
Deposed as a witness. Have you got your statement recorded?
Regarding that, that's why I want to see the lower court, Your Lordship.
You have not done so.
Your Lordship.
So, argue? What do you have to say? Only point Mr. Manish Kumar is taking that he is not the deceased was not the employee. He was a gratuitous passenger in the truck, in the track. And the owner also said, no, he was not my employee. Admittedly, he was a passenger then.
As per the Your Lordship, claimant's case, he was not the passenger. But Your Lordship, I have to see what the reply was filed on behalf of the opposite party.
As per the claimant's case, he was
Khalasi, Your Lordship. As per the para 2 of the impugned order itself, Your Lordship.
How did he die?
Your Lordship.
He
The
was
fact
traveling on the tractor, it overturned, my lords.
He was traveling on the tractor.
Yes.
On what capacity?
he was the cleaner, Your Lordship.
How can you say, Mr. Sabyasachi?
In para, as per the para 2, Your Lordship.
What
Not
para 2?
of the judgment, Your Lordship.
The judgment is under challenge.
Your
What
Lordship.
is your statement? He was not your employee. Your statement is he is not your employee.
As per the
How can
para 5
you
of the impugn
go
order.
hot and cold at the same time? What is the para 2? It is their claim, which you reject, which you confront, which was confronted, and you say no, it is not correct. He was not my employee.
Your Lordship, let it be after 2 weeks, Your Lordship. In the meantime, I will see what the stand was taken by the owner. Then, Your Lordship, it may
You
be.
don't know what you mean to say you don't have the proper file?
Your Lordship, I have only this notice, Your Lordship.
Very good.
That's why I want to see.
What a sorry figure you people are cutting. This entire proceeding now is live stream. Everyone is seeing this, and see how sorry figure you people are cutting. People will understand throughout India what is the status of the lawyers of this Jharkhand High Court. I'm sorry to say this.
Lordship, in the appeal, I cannot change my stand, Your Lordship. That's why I have to verify
So
that.
what is verify? So you are appearing without having the papers with you. Claimants will not suffer because the insurance company will pay, and you have to recover. Whether they are the cleaner or not, it is immaterial for the claimants. Even if they were the gratuitous passenger, you have to pay, and the insurance company has to pay, and they will recover from.
Only point is that, Your Lordship, if he was gratuitous passenger, then I have to pay, and if he was the khalasi, then it is the
As
insurance.
per you, he was not a khalasi.
Your Lordship, as per the para 5 of the impugn order, it appears. Your Lordship.
So impugn order is the final judgment. If that be so, then what is the question of filing an appeal? If the finding of the tribunal, if this award is final, whatever it says gospel truth, then where is the question? Where is the question? Where is the question of filing this appeal? Why does the law provides and gives opportunity to every party to file an appeal? The award is there, finished. What sort of submission you are making? And what is para 2? It is the case of the claimant,
Your Lordship.
which you have opposed. In a written statement, filing a written statement, by not admitting that, you say that in absence of any document, he cannot be treated to be your employee. There is no document. There is no document.
But court has found as is my employer. So that's
What
why.
basis? On what basis?
That's why it was insurance to pay.
What way? Insurance has to pay. They have to recover. The insurance company says that is a wrong finding in view of your written statement. If he was your employee, you should have filed your written statements, and you should have specifically by stating that he was my employee. Yes, he is my employee. I admit and own this. You have disowned him to his employee. Now face the music.
Let it be after 2 weeks, Your Lordship.
Mr. Manish Kumar, appearing on behalf of the insurance company, argues the case merits. First up, he submits that the claimants claim that the deceased was the employee of the owner of the tractor. But in the written statement, the owner has denied the aforesaid fact. He submits that, that being so, the finding of the tribunal that the deceased was the employee of the owner of the tractor is, and owner of the tractor and was attached with the tractor is not correct. Full stop. Next paragraph. This is the only argument which has been advanced by the counsel for the appellant. Full stop. During the course of argument, he submits that in these cases, if it is held that in these cases where the deceased is a gratuitous passenger, he will get a right to recover the amount from the owner of the vehicle. Full stop. Next paragraph. The owner of the vehicle, Mr. Sabyasachi, submitted that the tribunal has found that the deceased to be his employee. He submits that deceased also claimed to be his employee. Thus, there is no error in the award. Full stop. Next slide. When I go through the written statement, I find that the same owner did not admit that the deceased was his employee. He said in paragraph, where is the claim application? Take down. In column number 5 of the claim application, it was mentioned that the deceased was an employee of the owner. Full stop. In reply, the owner in the written statement has not admitted the aforesaid contention. Full stop.
May I submit something more?
Full stop. If this clearly suggests that they are denying the assertion made by the claimants to the effect that the deceased was employee of the owners. Full stop. Full stop. Next paragraph. Now, during the argument, orally, the counsel submitted that since the tribunal has held that the deceased was his employee, it has to be treated to be his employee, and the insurance company should pay the amount of compensation. Full stop. So prima facie.
Only one thing, Your Lordship, if Your Lordship permit me.
Yes.
Your Lordship, in page number 21, opposite party number 3 and 4, owners of the offending vehicle have not specifically denied that the deceased was.
Where is the question of admission? You have to admit.
And Your Lordship, AW1 and AW2 both have stated that he deceased was the employee of the.
Where is the question of AW1 and AW2 when the owner himself says that he is not buying?
On the basis of their statement, Your Lordship, this income has been assessed.
First up. Next paragraph. Prima facie, the submission of the counsel appearing on behalf of the owners cannot be accepted, as the owners cannot be allowed to take a diametrically opposite stand in this appeal than what has been mentioned taken in their written statements. When they have not admitted in the written statement that the deceased was his employee, now it cannot be he cannot be allowed to take a stand that the deceased was their employee. So far as the payment of compensation is concerned, this court is of the view that even if the deceased was not an employee and was a gratuitous passenger, the claimants are entitled to receive compensation from the insurance company. But in that case, the insurance company will have a right to recover the same from the owner. Full stop. Next paragraph. Prima facie, from the argument of the owners, this court is having a feel that the owner is trying to establish the deceased to be his employee, so that he may not, so that the right of recovery, he can evade the right of recovery. Full stop. Next para. At this stage, Mr. Sabyasachi prays for some time to address this court. Mr. Prayer allowed. Is this case after 1 week?
2 weeks, Your Lordship.
2 weeks. You yourself has fallen in the trap, Master. You have created the trap yourself.
Your Lordship, I cannot change stand, Your Lordship, as what was taken in lower court.
Yes.
Serial number 35, MA number 477 of 16. Mr. Manish Kumar, Mr. Amit Mishra, for the Mr. Suraj, for the respondent.
Lord, I am appearing for the claimant.
This is a case of injury, my lords, and the injured claimant was working as my lords in the police department, and he was, my lords, treated by at the government expense. He was also promoted after the accident. Still, the my lords, the tribunal has granted him, my lords, pecuniary loss to the extent of 40% towards loss of income. This is the only thing under challenge, my lords.
You are who is appearing for the claimants?
Lord, I am appearing, lords.
Show me how you suffered a pecuniary loss.
My lord, I have documents have been exhibited before the learned tribunal. My lord, I was admitted in the hospital, initially in RIMS. Thereafter, I was admitted in Guru Nanak Hospital. There also I was not, my lord, his leg was not properly treated. Subsequent thereto, he was treated at Ram Pyari Hospital. So in treatment, my lord, he was...
Treatment how much?
1,94,506.
How much?
1,94,506. Page number 17, last paragraph.
Page number 17, last paragraph.
As per plaint, the claimant is...
This petitioner is?
ASI.
He was at the relevant point of time, he was ASI, my lords.
So during that entire period, have you received your salary?
My lord, because to that effect, there is no averment whether he was working or not. He has not.
You should give that averment that I was not working, I was not paid.
But I have gone through his deposition, but in his deposition that has not come whether he was working, he was granted promotion.
That means he has received. It cannot be said that he has not received. Then this total loss, how much? This 29,000, has your salary been decreased?
No, lords, to that effect, my lord, I am not.
It has also not been decreased. For this permanent disability, you have not suffered any pecuniary loss. There can be a mental trauma,
my lord,
and pain suffering.
Yes, my lords. Because of this incident, my lord, the document, disabled certificate has been.
How does it affect? So tomorrow, Mr. Counsel, if I become 30% disabled, but there is no effect on my work and I'm getting salary, the government has paid me the entire salary and is paying me also, giving me promotion and giving me the enhancement of salary also. Where is the question of pecuniary loss because of this accident? You are not, it is not a windfall. This is not a lottery for you. You are an ASI, you are getting your monthly salary. If it was your case that yes, for X period to Y period, I was without pay, then you are entitled to get everything. It is not your case also.
My lord, I was only praying that in this case, there is no document brought by the or any evidence brought by the insurance company that after this incident he was.
Why will insurance company bring on evidence? It is you are the claimant. Onus is upon you.
Because whether after that incident he was, whether after this incident he was working or not and he has got promotion, to that effect there is no evidence.
You have to say. You have to say.
In his deposition he has not said so.
So, what is the amount which has been paid on medical treatment?
The amount is medical expenses 1,94,506.
Now I am asking you a question. You are entitled for reimbursement of this medical expenses. Have you got reimbursements as a government employee?
My lord, I have not taken instruction because that is not there in his evidence also, because so that I will have to take instruction.
If you receive this 1,95,000 and if it is found that you have received reimbursement of this amount, I will direct them to initiate a departmental proceeding against you for and initiate an FIR for financial irregularity. Seek all these instructions.
I will take instruction, my lord, whether he worked thereafter or not, or he was granted promotion.
Pain, suffering is concerned, you are absolutely entitled to, and you are entitled to much more than what has been given to you.
Yes, my lord, your lordship is right.
More than what has been given to you. But so far as medical expenses is concerned, and this you seek instruction.
I'll take instruction, my lord.
LCR is here.
No, my lords. It requires to be called for.
You have withdrawn 2,50,000.
Lord, I'll take instruction because this honorable court has directed the insurance company to deposit perhaps, but I don't have instruction whether he has withdrawn or not.
Seek instruction to that effect also.
I'll take instruction, sir.
Mr. Suraj Singh, please try to take necessary instructions in this case about as to whether the amount so deposited by virtue of order dated 11th August 2017 has been withdrawn or not. He will also seek instructions on the pecuniary loss, if any, sustained, and in respect of reimbursement of the medical bills. Full stop. Next para, call for the lower court records and list this case thereafter.
But I only pray, my lord, that this order may be uploaded on the website so that I can take print of it and take instruction from the.
Yes. You know on what issues you have to take instructions.
Yes, my lord.
You know very well. If you have any doubt, just rewind this live streaming. Your client must be also hearing this, is watching this. You also be knowing.
But at least this is one of the benefit we are getting this live streaming, because we are, at times we are not able to record what order has been passed for compliance. So this helps a lot.
499 of 16. Mr. Jaspreet Mukherjee, Mr. Anjani Kumar, Mr. Pooja Kumari, Mr. Amrit Anshu Singh for the appellant,
I am appearing on behalf of the appellant, Your Lordship.
Yes.
Your Lordship, same prayer for not today on behalf of Mr. Nikhil Ranjan. This may be kept any day in the next week, Your Lordship.
Okay, on the health ground of Mr. Nikhil Ranjan, prayer has been made to adjourn this case. Learned advocate Mr. Nikhil Ranjan. Prayer allowed. This case is adjourned.
Obliged, Your Lordship.
Hello. So, second update, दूसरा वाला सुन ना